Good afternoon, or almost good evening. My name is David Lepofsky. I'm counsel with the Crown Law Office Criminal at the Ministry of the Attorney General. I'm speaking in my personal capacity tonight. Welcome to the third webinar in a series which I'm hoping will continue on to at least the fourth and fifth installments on strategies that lawyers and paralegals can use to help ensure that our court system is fully accessible to people with disabilities. If you've taken the first and/or the second webinars, this will add to your knowledge. If you haven't, I'm going to give you a quick summary of what went on in the first two webinars and strongly encourage you to go back and take those programs if you have time. This qualifies as professionalism hours for your CPD requirements, and we hope you find it helpful. Also, at the end of the program today, we'll have some time set aside for questions, so feel free to email in questions before the program is out, and we'll try to get to as many as we can. We have over 1.7 million people in Ontario, or over 4 million people in Canada who now have a physical or mental or sensory or learning or intellectual disability. That number is going to grow. It's going to grow because the most common cause of disability is aging, and proportionately our society is aging. But even that underestimates or understates the extent to which people with disabilities pervade our society. Ultimately, everybody now has a disability, or at some point in their life will get one if they live long enough. So the topics we're covering in these webinars actually bear not on some small minority, not on some large minority, but indeed on a minority of everybody. People with disabilities can end up in a courtroom either as an accused, a witness, complainant, a lawyer, a plaintiff, a defendant, a juror or prospective juror, a judge, a court staff worker, or a member of the public who's come either to support one of the court participants or simply to exercise their constitutional right to attend court. These folks face too many barriers when they try to take part in our court system. Some of the barriers are physical, some of our courts are old and were not designed for full accessibility. Some of the barriers we face are electronic or technological. Some are information barriers, some are communication barriers. Our law requires that our court system become fully accessible to all court participants with disabilities. Lots of different laws require that. The Charter of Rights in Section 15 guarantees the right to equal protection and equal benefit of the law to people with a physical or a mental disability. Provincial Human Rights Code guarantees the right to equal treatment with respect to services and facilities without discrimination because of a physical or mental disability. Adding to these, the Accessibility for Ontarians with Disabilities Act, or AODA, passed in 2005, requires Ontario to become fully accessible by 2025. And it requires the Ontario government to lead us there. Whichever law you turn to, the result is the same. These webinars are seeking to provide you with practical tools because lawyers and paralegals have an important role to play in helping remove and prevent barriers in the court system. They can't remove or prevent them all, but they are in a unique position to help. Let me give a very quick overview of what the first two webinars cover. In our first webinar, we talked more generally about the kinds of barriers that there are in the court system and generally about strategies overall to address them. We learned in that webinar that in 2005, then Chief Justice McMurtry appointed a joint committee of the bench, the bar, and the government to develop an action plan on how to get from a court system that is inaccessible to one that is fully accessible. That committee, chaired by Justice Karen Weiler of the Court of Appeal, yielded a report, which we call the Weiler Committee report, in 2006 or 2007. I was one of the participants in that committee. It's available in your materials available for this webinar. It's a good read. I recommend it. It's not very long. It documents the kind of barriers that recur, provides a vision for what a fully accessible court system would look like, and provides practical strategies for the government, the judiciary, and the legal profession to overcome those barriers and achieve the goal of full accessibility. In our second program, we focused on two specific disabilities. We had a panel that talked about the kinds of barriers that face people with hearing loss, whether they're deaf, deafened, or hard of hearing, and on strategies for enabling them to fully participate in the court system. It turns out that the largest single group of accommodation requests that we get in the court system, as far as we can tell, are from people with hearing loss and who need communication supports. The other panel we did was a wide-ranging discussion of how to accommodate the needs with mental health issues in the court system. Today, in our third in this series, we're going to focus on two other disability groups. First, after I finish this introduction, we're going to talk about people with vision loss. I'm one of them. I'm totally blind. And second, after a lively discussion about how to accommodate the needs of people who can't see much or can't see at all in the court system, we will have a discussion of how to accommodate the needs of people with intellectual disabilities in the court system. So there's your roadmap. And we'll conclude, as I said, with an opportunity to give you responses to questions you might send in. But let me just offer two introductory thoughts that derive from the two webinars we've done to date. The first is that the most important thing that you as a lawyer or paralegal can do is to try to identify as early in the court process as possible whether you have a client or a witness or some other court participant who has a disability and needs it accommodated, needs that disability to be accommodated. If you show up to court on the first day of a trial and say, oh, by the way, we need an accessible courtroom, or we need a sign language interpreter, or we need materials available in Braille, the court is far less likely to be able to meet those accommodation needs on the drop of at the drop of a hat. On the other hand, if you alert the court well enough in advance, the court is in a much better position to try to organize the accommodation, the means needed to provide the accommodation requested. And to that end, and as a result of the Weiler Committee report, the Ontario government, to their credit, have established in each major court facility one public official, one court services worker, who is the point person on accessibility. They're the accessibility and accommodation coordinator. They don't actually deliver all the accommodation, but they're your one-stop shopping. Go to them with a request, go there early, they can see about what's needed. They may tell you you've got to raise it with the judge. They may be able to administratively help you deal with it or let you know where to go. And as we learned in the first program, sometimes the requests get very, in a small number of cases, are somewhat more complicated. And there are folks back at the Ministry of the Attorney General head office who can help swing into action to arrange for more complex accommodations. So canvassing your client, canvassing witnesses to find out if anybody has a disability that requires an accommodation in the court process as early as possible, letting the court know as early as possible, is the first important point that we identified. The second is, beyond the fact that it's obviously a good thing to do to address these needs, an important thing to do, and as a lawyer or paralegal, a satisfying thing to do to take steps that help ensure that people of all abilities can fully participate. It's important to also be aware of your legal obligations. Under the Human Rights Code, there's an obligation to provide equal access to services and equal treatment in services. That includes legal services. So any law firm or law office should be looking at the services they provide to make sure that they are fully accessible to clients with disabilities. Under the Accessibility for Ontarians with Disabilities Act, an accessibility standard was enacted in 2007 called the Customer Service Accessibility Standard. It sets out requirements for barrier-free service. In 2011, another accessibility standard was passed. It's got a long name, the Integrated Accessibility Standard Regulation, or IASR, but it includes some specific requirements that your law office or law firm has to consider to ensure accessible customer service. Most notably, it includes specific requirements about providing accessible information and communications to ensure that people with varying disabilities, if they have faced challenges either communicating verbally or reading printed material, that you provide alternative ways to ensure that they're able to fully participate. The online resources we've connected you with for this program includes links to the Ontario government's helpful policy guides and online tools that will help you navigate those standards to know what your obligations are as a a service provider to clients or customers. As well, under the Disabilities Act and under the Human Rights Code, it's important for you to consider and to think about your obligations as an employer. Whether you describe it under the Disabilities Act or under the Human Rights Code, we all have an obligation in our workplaces to provide for a barrier-free workplace. To that end, an accessibility standard was passed, which are the resources that we provided you will help you find your way through, dealing with barriers to equal access to employment. That's been enacted under the Disabilities Act as well. And it's worthwhile for you to take a look at those, make sure that your law office is up to speed on those. Removing barriers to the workplace will often also help you ensure accessible customer service. Helping ensure accessible customer service will also help you ensure that you have a barrier-free workplace. And both help your organization succeed in meeting the full range of possible clientele out there, including that minority of everyone who constitutes people with disabilities. Now, with that introduction in mind, let me leap right into our first panel. Our first panel is going to be a discussion on meeting the needs of people with vision loss. I want to introduce, Rob, if you could bring the camera back so we've got my two panelists in view here. I'm joined by two of my colleagues, Shona Pickens and Alexandra, I always mess up your last name. Help me again. Papakonomou. And I'm called Lepovsky, and everybody stumbles over that. Alexandra and Shona both have vision loss. I want to learn a little bit about each of you. So in a nutshell, could you each, starting with you, Shona, can you tell us where you work, how long you've been working there, and how much you can see?
I work at the Peterborough Crown Attorney's Office as an assistant Crown. I have been a Crown for close to 9 years. Most of that time has been in Peterborough. I have no sight in my left eye, and I have about 5% vision in my right eye, so I read up very close to my face, and I can't see distances, and I can't just read a regular computer screen.
And for walking around or navigating, do you use a white cane or a guide dog?
I don't use either.
You can navigate with your guide, with the vision that you do have.
Yeah, I have some challenges with depth perception and things like that, but right now I'm managing.
Okay. And Alexandra, how long have you been a lawyer? Where do you work? And how much can you see?
I've been a lawyer for about a year. I practice in London, Ontario, and I represent landlords and retirement home operators, so I'm in private practice with Cohen Hiley. I lost my vision in my teens, and so I've adjusted to both experiences, and I travel using the services of a guide dog.
And before you lost your vision, did you have 20/20 vision or did you have limited vision?
I had 20/20 vision until I was about 6 or 7, and then it started to deteriorate, but very slowly, so I didn't realize it was happening until I, one day couldn't see something that I could a week or a month before, so it was very gradual.
Okay, well, thank you. Let me just, before we involve our panelists a little more, let me tell you just a little bit about me, a little bit about vision loss, and then I'm going to do a little technology demonstration for you. In terms of myself, I've been a lawyer in practice with the Ontario government since 1982, so we're upwards of 32 years now. I did civil litigation, then constitutional litigation, and for the past 20 years I've been doing criminal appeals for the Crown. All our courtroom practices in varying degrees, and all of course involve a lot of reading. I am now totally blind. When I was born, I had no vision in my right eye. I had partial vision in my left eye. That sounds like it's roughly what Shona has. I could read if I held printed material up close. I could walk around navigating using my eyesight. I should not have been riding a bike, but I did, and so on. In my teens, my vision started dropping gradually. It was pretty much all gone, and then absolutely all gone partway through law school. So I am now, and for since the late 70s, I've been totally blind. Let me just tell you a little bit about the population of people out there with vision loss. CNIB advises that upwards of 1 million people in Canada are either totally blind or have significant vision loss. That means enough vision loss that it can interfere with performing tasks of daily living without some adjustment. Now, of that population, almost half are 65-year-old or over. So just the experience you know from friends and family, you get older, your eyesight gets worse. The significant majority of that population has some vision. It's only a minority of people with significant vision loss are totally blind. And the number of people who are totally blind from birth is extremely small. It's a very small number. The difference in the experience of being born blind on the one hand and losing vision during your life is very different. Someone who loses vision, like Alexandra or me, had it, used it, and then suddenly had to experience, or gradually had to experience, the loss of it, and to develop alternative means for doing activities that sighted people use their vision for. There are really three major areas where they have to make adjustments. One, the first and perhaps foremost, is orientation and mobility, learning your way around. Alexandra, you use a guide dog. I use a white cane. There are other gadgets that can be used now, talking GPS and so on, to enhance one's independent mobility. But you have to train, whether it's with a guide dog or with a cane, to acquire those mobility skills. The second area is reading and writing. If you were using print before, you may not be able to anymore, or you may need adaptive technology to help you use it. And the third area for adjustment is what they generally refer to as activities of daily living. Cooking, dressing, labeling clothing so you know what color, cleaning, personal hygiene, and so on. Things that a sighted person uses their eyesight for. There are other ways to do it. You've got to relearn all those tasks. Lots of people do it, of course, and so it's not exactly new, different, or revolutionary, though with new technology that we'll discuss in a couple of minutes, lots has changed about how to do it better. Someone who is born totally blind has a different experience. They don't experience a loss. They don't experience a loss any more than you experience a loss because you don't have wings and can't fly. I mean, as far as they're concerned, they are the way they always were. Also, a person who is born with vision loss has certain areas where they need to have their learning enhanced. Sighted infants, children, learn a lot about the world just by looking around. Blind infants and toddlers have to learn spatial concepts. What is three-dimensional space? What is a wall? What is a corner? All those things have to be learned through active teaching. They can be learned, of course, and lots of kids who are born totally blind or with very little vision learn it well and grow up and are very successful, but they have to be actively taught. For them, Braille or other access technologies for reading aren't something you learn afterwards to make up for the loss of reading print. They're their first medium of communication. So that's kind of a bit of an insight into the difference between experiencing vision loss partway through life, which is what anybody watching this webinar is more likely to experience, versus being born with vision loss or no vision at all from the outset. Now then, let me focus for just a couple of minutes before I involve our panelists again on the issue of access to printed material. And I want to, the olden days, when I was in law school in the 70s, involved either, if you knew Braille, having somebody manually transcribe, learning to type Braille and transcribing from print to Braille, very slow, very cumbersome, very little material was available, or involving having human beings read to you or having books read on tape. And it made one very dependent on other people to read things to you, or recording services like CNIB's audio library to prepare materials. The world of access to printed information in my adult lifetime has changed radically. We have tons more access to tons more information, much more easily and much more independently. I'm going to do a demonstration, Rob, if we can put my computer screen up on the screen and get the audio coming out of my computer. I have sitting in front of me a computer. It's a Lenovo computer. It's running Microsoft Office 2010, but it's also running a program called JAWS, which is a screen reader that many people with vision loss use, and it enables me to have the computer read to me. You should be able to hear what I'm going to be hearing.
Document 1 compatibility mode Microsoft Word print.
That probably sounded a little fast to you. I'm going to slow it down. I listen very quickly,
Slower.
as do many people
Slower.
with vision loss. So I'm
Slower.
doing a key
Slower.
combination.
Slower. Slower.
Slower it down. Now I'm in front of a Microsoft Word screen.
Document 1 compatibility mode Microsoft.
And I'm just going to type a short sentence here. I do not have it read each letter as I type. It would drive me crazy. I have it read each word when I hit the space bar. So I'm going to type the word the, space.
The. Way. I. Right. Is. I. Typing. Like. Anyone. Else. Period.
Now, I can now read that whole line by one key command. I'm going to just do an up arrow.
The way I write is by typing like anyone else.
I can slow it down if that's too fast for you.
Slower. The way I write is by typing like anyone else.
And just to get a sense of how those of us with vision loss will work,
Faster, 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 faster. The way I write is by typing like anyone else.
That may sound a little fast for you, but that's the way I'm used to going. I
Slow,
will
slower,
slow
slower,
it back
slower.
down. We can navigate by word. I'm just doing a particular keystroke combination.
Period. Else. Anyone. Like. Typing. I. Is. Right. I. Way. The.
Now I hear that ding, means up the start of the line. Now I'm going to go forward one word at a time.
Way.
Go back.
The.
I can go one letter at a time.
H. T. H. E.
And I know that that's a capital because you're going to hear a difference. When I go backwards,
H. T.
the T is slightly higher pitch, and that's a prompt that it's a capital letter as opposed to a lowercase
H.
letter. Now I can then, as with any word processor, you can do, I'm just using Microsoft Word, and JAWS enables me to access it. Now this is a very simple screen. I've just added a line. Let me show you what reading is like. I'm going to call up a document.
Alt, comma, F, multi-log, input.
Oops.
K, T, A, J, blank. Crown factum in the Supreme Court of Canada, Jackson 356.
This is a factum in a case. I actually wrote this factum
Slower,
in a murder
slower,
case
slower,
that we just had in
slower.
the Supreme Court of Canada recently. and I wrote it on this computer, and I'm going to have it read just a little bit of it to you.
SCC file no 35622 in the Supreme Court of Canada, BETWEEN. Her Majesty the Queen, Respondent, and Douglas Jackson, Appellant, Factum of the Crown Respondent Overview, Section 2, Page 1. 1. The appellant tried to rob Campbell, a drug dealer, gunpoint
I'm going
at...
to slow it down for
Slower,
you.
slower, slower. 1. The appellant tried to rob Campbell, a drug dealer, at gunpoint. Moments later, he fatally shot Campbell 4 times. He claimed self-defense, yet one shot was to Campbell's back. 2. Murder. First that...
And just to give you a sense, in a particular case, when I'm working, I will get transcripts from the court reporter. My secretary will get it as Word documents. I can read them on the computer. I can make notes on the computer the way anybody else would on a computer. In fact, if I have a document in Word format or on an accessible web page, basically I can read anything a sighted person could read, and I could do so independently, store it on the computer, carry it wherever I want. Let me close this document.
Control W.
Now,
Document 1.
you might want to ask whether all documents are readable no matter what format. And the answer is no. If you create a nice, just pure text in Word, that's no problem. PDFs can be a real problem. Some PDFs have some capacity to be read, others don't. And we never know when you get a document where it says PDF at the end, whether it's going to be accessible or not. Let me call up an example of one I can't read, but you, I would believe, will be able to read it if you can see and look at the screen.
Alt, comma, SCC. Inaccessible PDF document. .pdf Adobe Reader. Ready progress. RE only. 0%. Slower, slower, slower. Alert empty document.
All it says is
Alert empty document.
alert empty document. This is what this is it's printed text, but it's been scanned in. And any graphic image like that is, as far as I'm concerned, an empty document. Solution, if you're ever providing information to someone with vision loss that you've got in a PDF format, it's important to always also provide it in an accessible format, like a nice, simple text-based Word document. And if you ever hear from someone that PDFs can be made accessible, my advice is don't believe them. It's hard to do, and even when it is done, it's rarely done properly, and it's never fully accessible and easy to navigate the way a Word document is. But some PDFs you will open and it will be able to read, others you won't. Some will even hang your computer, and we won't even know that until we've actually opened it and found out it says alert empty document. What about web pages? Well, some web pages are very accessible, and if your firm has a website, you should be looking into the accessibility requirements under the integrated accessibility standard regulation, because there are now legal obligations for making a website accessible. But let me just demonstrate for you an accessible one.
Document 1 compatibility mode. American Foundation for the Blind homepage. Windows Internet
Here's
Explorer.
a nice accessible website. This is the American Foundation for the Blind website. Again, I'm slowing it down for you. And what happens is I'm going to hit the tab key.
Living with vision loss, heading level 2 link.
And you see it said living with vision loss, heading number 2, link. When I hear link, I know I can click on it. I'm going to hit another tab.
Eye conditions link.
Eye conditions link. That means it's something I could click on to learn about eye conditions.
Losing your sight link.
Losing your sight link.
Using technology link. For parents of blind children link.
I'm just hitting the tab key, tab.
For job seekers link.
Tab.
For seniors link.
Now, that's a really nice accessible screen. Let me take you to a really lousy one. It's a restaurant in Manhattan, and it's got a website.
Jack's wife Frida for seniors image.
Which is very graphical. I'm going to tab through it, and you're going to hear what I hear. Tab.
Jack's wife Frida / 296,402,467,073,013 image map link.
I'm going to hit the tab key again.
Info at Jack's with a Frida image map link. Jack's with a Frida image map link. Snap widget vertical bar Instagram username widget frame. 1035831273208796664 103495991
These kind of links drive us all crazy. They just drive us completely crazy. So there are websites that are accessible, there are websites that are inaccessible. If your firm or office has a website, make sure your web developer is instructed to make sure that they post materials in an accessible format. By the way, that also makes it easier to use on a PDA. And similarly, it is something which is, I should say, it will also, how would I put it? Well, what I would do is I would instruct your web designer, make sure it's accessible. If they don't know what it is, tell them to find out. And if they still don't know what it is, I'd find a better web designer, because any web designer who doesn't know how to design an accessible web page, to my mind, really shouldn't be designing web pages. Rob, if you want to just bring the picture back up to me for a minute. How do we get information into the computer? Let me just demonstrate something. This is really interesting. I mentioned in the olden days, we used to have to get human beings to read to us. With the advent of optical character recognition and scanners, that enabled us to be able to take a document, scan it, have the computer recognize it, and read it out loud, convert it into a text document like Word, and so on. That, in turn, still meant that you had to have a big scanner to lug around, which wasn't practical. What has now come along in the most recent years are portable devices. I've got one right to my left here. It's called a Pearl camera. It's plugged into my computer, and I have a book here. I've got the book lined up. I'm going to now ask you, Rob, to put the computer back on the screen.
Alt-Control-O.
I'm opening a program called Open Book.
Welcome to Open Book version 9.0. And read.
I'm going to slow down the voice.
Slower.
I'm going to turn
Camera
the
light
light
enabled.
on. I'm now opening the book that's on the desk in front of me, in front of that camera I showed you. It's just a hardcover book. I've opened it randomly to any page. I don't know which page it is. I'm not going to hit the space bar. You're going to hear a camera click, and it's the camera that's mounted over the book that's going to take a picture of the book. And then...
Informed choice in medical care. 253. Benefits if he continued at his job. That there was no more logical than apparent. That there was no immediate emergency making the imperative. That there was a
Rob,
grave
if you
risk
could
of a
just
stroke or
take
worse
the
during.
computer off the screen, please, and come back to looking at me. So, folks, if you're looking at me, you can see I've got a book here on my left in front of the Pearl camera. This is a mounted camera. What it did is it took a picture of that page, sent the signal to my computer, and you saw that within about 1 second of the click sound of the camera, it was actually reading what's in the book. What that means now is for a person with vision loss, we could pack a device like this up, carry it in our briefcase, sit down anywhere, and start reading. Somebody hands you a book, somebody hands you a document. If it's a text-based document, you can just start reading. Let me do one more, show two more little quick show and tell things. Neither involve my computer, so I don't need you to be looking at my computer screen anymore. I'm going to close it up. How do people who read Braille interact with a computer? I'm holding up a device called a refreshable Braille display. And what it does is it's got space across the front of it for 40 characters of Braille, little pins that come up to show in the formation of the letters. You can either Bluetooth connect this to an iPhone or cable connect it to a computer. And a person who's a heavy Braille user can be reading what's on the computer screen one line at a time by running their fingers over this. Now, I'm not a great Braille user, but I have it available. But somebody who's a very heavy Braille user could be banging away, taking notes on this, or interacting with their computer without using any voice output at all. I mentioned an iPhone. The other thing I'm going to show you, and the last thing I'm going to show you as part of this demonstration, is an iPhone. Now, you might think, how on earth would a blind person use an iPhone? Because it is flat screen. But the iPhone actually comes, in fact, all the Apple devices come with an onboard voice that you simply can launch. You don't have to pay anything extra for it. So here's my iPhone. You can't actually see the screen right yet because I have it blanked out because it saves battery. But I'm going to turn the screen back on with a particular stroke here. Now you can see my screen. I'm going to flick my finger, and it's going to announce the various icons on the screen.
Camera. Double tap to radio folder. Games folder. Weather. Voice stream.
Now it just said voice stream. I'm going to double tap. It's going to open it. And it's opening. Voice stream is an app. I think it costs $10 or something. And it's a document reader. So I now have on the screen, on my iPhone, that same factum from the Supreme Court of Canada that I showed you before.
Position. Remaining time 2 hours. Position. Elapsed. Search. Navigation unit. Play. Button. Adjust.
Overview 1. The appellant tried to rob Campbell, a drug dealer, at gunpoint. Moments later, he fatally shot Campbell 4 times.
This is the same factum I demonstrated in my computer reading with JAWS, but in this case, it's a $10 app which I can load on my iPhone, and I simply copy the document over, call it up, and I can read it on my iPhone without having to lug a computer around. So the moral of the story is in the area of accessibility to print information, people with vision loss, if they can get access to this kind of technology, can get access to tons of information much more easily than ever was the case when I was in law school in the 70s. Now, with that, let's talk about how this can affect you when you're in practice if you encounter a person with vision loss. I want to now involve both of my colleagues, Alexandra and Shona, in the discussion. So we've talked about how I access printed information. I want to ask you each how you access printed information. Shona, can I start with you?
Yes, I have the use of a CCTV.
CCTV meaning closed
circuit television, and basically it works similarly to David's Pearl camera in that I put a book underneath a camera and it will magnify on my computer screen. And I just move the tray along and it will take me through whatever's printed there. I use a program on the computer called Zoom Text that basically does what JAWS seems to do, but in a large print fashion, and I can increase the magnification or decrease it. It tracks with me, and I can see it. It has a voice function that I haven't been using, but I do use the enlargement software.
Okay, and what about writing?
For writing, I take notes on my laptop in court, and I can also handwrite. I prefer not to due to these. I would have to get down about an inch away from the table in order to see it. I also, in court, because my closed circuit television is not portable, I have glasses that are basically have a protruding magnifying glass coming out of the lens, and that allows me to magnify anything that I would be reading in court. And
while Shona doesn't use a portable magnifying technology, there are coming out on the market now a number of options that do that, and they're getting more and more portable all the time. In fact, the Pearl camera I was just demonstrating, well, I use it as a blindness support for someone who can't read print at all. You can also use it to put a book under the camera and enlarge the print. It'll just show take a picture of the page and then blow it up on the screen. Alexandra, how do you read and write?
So like you, I use JAWS, and a lot of the technology you use, I use a scanner for documents. Now in my firm, if there's any document, I would say over 10 pages long, I send it down to our copy center and they produce it in a format that I can access. Anything smaller than that, I just scan. I have a scanner at my desk, and so I use that. When I'm in client meetings or in court, I use a device called a Braille Note, and that has a Braille display on it. It also has a voice output, but I put headphones in so that it's not disturbing and so that no one else can hear what I'm typing. I use that so that I can track what I've written using the Braille feature, and I especially like using that in court because I can jot down notes and create questions that I can use on cross-examination, and it's just very discreet. It's since it doesn't have a screen, no one can see what I'm writing, and also it's not an obtrusive barrier between me and my clients.
Now, just so folks know, the Braille Note is sort of similar to that Braille display I showed you. In other words, that you can keyboard in Braille, and then pins come up in the shape of the letters in Braille. So you can both read Braille and write Braille on it, but you're never involving a piece of paper in the entire process. One interesting thing that comes from this, and I hope you'll take this as something that applies to everything we talk about in these webinars. Alexandra and I have the exact same amount of vision, none, but we both use different technologies. I don't use Braille for note-taking in meetings at all. There are a range of different technologies. We've illustrated some. People with the identical disability may function at very different levels and may use very different adaptations. And it's wrong to think that, oh, you're blind, you use Braille. Frankly, majority of blind people, I think, don't use Braille. You're low vision, you must use a magnifier. Some do, some don't, and so on. Bottom line is, in every case, if you've got a client or a witness with vision loss, it's best to ask them how they access print information and what best you can do. It might be a matter of you simply emailing them a document in a Word or a text-based format, and then they'd be able to read it. Or some may ask you to print it. In some cases, if you need it produced in Braille, there are transcription services. You can email a document, they can produce them in Braille. But it's worth asking people what they use and not to just assume, oh, you're totally blind, you must use Braille or whatnot. Let me go back to something a little more rudimentary, which is, I ask you both, how do you know if someone has vision loss? You're going to deal with a case, you got a witness. A case of myself, or I use a white cane, Alexander uses a dog, but Shauna, you don't carry any kind of symbol that signifies you have vision loss at all.
No.
So how do people know?
Well, they'll see me reading, or they notice that my eyes, I can't focus where my eyes go, so they go off to the side, and so people start to kind of get it, but it takes a while. So there are different cues for different people. You know, I watch to see if people are reaching out for things like doorknobs or chairs or things like that, and I'm able to detect whether they need some well, to at least be cued to ask whether they need some assistance.
All right, now, do you ever just let people know you have vision, you have partial vision?
Yes, I do.
What sort of circumstances?
Well, in court, if I know that we have a new judge, I will, I don't like to make a thing of it in court, but I will ask the clerk to let the judge know when they go back to get the judge that I do have a vision impairment. When I'm dealing with a jury, I address it right out of the gate with the jury so that they're not distracted by it. The last thing I would ever want is for a jury to be kind of looking at me going, what's she doing? Rather than looking at the evidence that I'm presenting. And with witnesses as well, if I'm going to be working with them for any length of time, I do point it out to them.
Right, now, in the case of those of us who carry a white cane, anyone, the only people who might not know that we have vision loss is someone else in the room who has vision loss and doesn't see the cane. Are there ever circumstances where some people with low vision might not want to reveal to others that they have low vision?
Yes.
What's that all about?
Well, sometimes they're in denial about it. It's come on slowly as they're aging, and so they don't they don't want to admit it to themselves. The other circumstance is that they don't want to center themselves out as different or requiring the help. They want to be independent and just try and get by without any sort of help.
Right. Okay, well then, let me move to the area of orientation and mobility, or finding your way around. So Alexandra, when you go to a court for the first time, a new court or a new tribunal, and you don't know the courtroom at all, what do you do?
Well, sometimes when I walk into either the courthouse or the building in which the tribunal is located, I will not know exactly where the courtroom or the tribunal room is, so I'll have to ask for court security or some other court official to assist me to find the room. And then once I arrive at the room, each room is set up so differently. So when I walk into a room, I just have to listen to hear where things are positioned. It's very rare that you get to the courtroom first or the boardroom first. So when that does happen, it gives me a good opportunity to sense where things are. But a lot of time I'm just listening and figuring it out as I go and trying to look graceful at the same time.
Shona, for you, is your vision sufficient that you need someone, is it sufficient that you can figure out the courtroom on your own, or do you need someone to help you learn your way around the first time?
The courtroom itself is usually small enough that I can figure out where I'm to be in the courtroom, but courthouse buildings themselves, the signs are often too high and too small. So if I'm going to a new place, I have to ask somebody to help me find a room or wherever I want to be.
In my case, I practice in the Court of Appeals, so I've been going to the same courtrooms for a long time. But in earlier years, I would appear in courts in different parts of the province. And I just make a point of getting there early before court starts. And if I'm with a student or just some court staff or whatever, just walk around the courtroom, get a sense of where the judge is, where counsel table is, and so on. So I get a sense of where to set up and where various people will be, if they're going to be witnesses or whatever. Assuming the folks watching this webinar are not thinking about themselves losing their vision, having to adjust to what we do, but instead they have a witness with vision loss who doesn't know the courtroom, or a client with vision loss, either totally blind or just low vision. What would you suggest is a good way for them to be helpful so that the witness or client can feel independently able to navigate the courtroom? Shona, can I start with you?
Yep. I think that the first thing you need to do is ask them what they need. Do you need an arm? Do you want to just follow me? And then I would take them through and orient them to the courtroom in whatever way they tell me that they're comfortable doing it. I want them to know where they're going to come in, where they're going to be sitting, where the judge is going to be, where the jury will be, and where I will be. So I would walk them through that. But basically, I think it's really important to ask them how to do that for them.
Alexandra?
One thing that, to start off with, especially witnesses, is if they're visually impaired, they may not know what proper court attire is, so I don't think it's at all offensive or inappropriate to kind of go over with them what you would expect in court attire. And one thing that I, just like Shona, just orientate them with the room. If you are unable to assist them ahead of time, have the court services officer describe the room to them. If they're a witness against an accused, maybe where the accused is sitting, because they might not want to be facing them. When they're taken to their seat, the most appropriate way to assist someone with vision loss in seating is to put their hand on the armrest of the seat, and then they can seat themselves. And the person escorting them to the witness seat, I would think, I don't think it's inappropriate also to stay for a second, make sure the person is seated in the right direction, facing the appropriate people, and if they haven't had a chance to be told where everything is ahead of time, give them a bit of a briefer at that point. So if you can't do it yourself, in conjunction with the person's feedback, of course, let the court services officer know what you'd like them to do.
Let me just add a couple of other thoughts, just building on what my colleagues have said. If it is a witness or who's going to be in the witness box at some point, what I would do is first I would have them sit in the courtroom where they will be sitting in the back rows, and then I would go up and I would stand at the witness stand so they could hear my voice and say, this is where you're going to be, and let them map it out by voice. And then I would guide the person from where they're sitting to the witness stand, and I would ask them if they want to go there on their own or do they want to be guided. And because often if I'm in a situation like that, I want to go on my own. So I'll just pace it a couple of times, get the hang of it, and then I can learn it. Then what I would do is I would have the individual, I didn't recommend you have the individual sit in the witness stand, and then you as the lawyer can go stand where you would be questioning them from, perhaps then go over and stand where opposing counsel would be questioning them from. If there's going to be a jury, I'd go over and then sit in the jury box while they're still in the witness stand, so they have a sense of where people are looking at them from. And then finally, this is of course when the court's not in business, go sit on the judge's bench and say, here's where the judge is. so that they have an audio map of where each of the key players are. And related to that is helping an individual vision loss with making proper eye contact. We all want to look at people when we're talking to them, and we don't always do a great job of it. The problem in the courtroom is sometimes you have to look at someone before they start talking. And so there's a risk of you looking the wrong way. And one of the strategies I use in a courtroom, if I'm at the counsel table and I'm not sure exactly where the judge is up there on the bench, I'll put my head down a little bit. And I would, if I had a witness, I would train them to do this. Just look down a little bit and say something like, "Good morning, Your Honor." And then if I say, "Good morning, Your Honor," then the judge will naturally say, "Good morning." And as they're saying good morning, I pull my head up and I lock my eyes on where their voice is coming from. It's a totally natural motion. It doesn't look weird. It makes people feel comfortable and at home as you're doing this. Let me move to the question of dealing with opposing counsel and documents. Alexandra, Shona, we are all used to being in court where counsel on the other side or a self-represented person hands you a piece of paper that they didn't give you before the hearing. And a sighted person would just look at it and read it. Shona, what do you do?
Well, for me, I have my magnification glasses, and if I can't read it using those, I rely on the assistance of the officer in charge of the case, and just take a moment with the officer to review it. Most judges are fantastic. If you say, "I just need 5 minutes to review this with the OIC," you're almost always going to get it, and that gives me the time to do it. And if we don't get that 5 minutes, it's a matter of talking back and forth between us and doing what I can that way.
Alexandra.
Well, if I'm there with my client, ideally my client would assist me in reading it. If I don't have something portable that can assist me. So when I appear independently, I usually take some sort of mechanism to be able to read documents. But if I'm provided with a 75-page brief of documents, there's no way for me to really read that in a functional amount of time before the hearing. So in that case, then we have to look at adjournments or...
And that leads to what I practice as a preventive measure and have throughout my career, and it really hasn't been a problem because of it, which is that I will notify opposing counsel if they don't know me already that I can't see, and if there's any documents they're going to be relying on, I need them in advance. And I think of a way to gently advise them that if anything is landed on me as a surprise, if they're not willing to just agree, if they say, "Sure, that's fine," then that's fine and we're done. But were there any recalcitrance about it, I make it clear that I'll bring to the court's attention, if I have to, the fact that my opponent knew that I was blind and asked for disclosure in advance, and they instead landed something on me in the courtroom. And in my experience, no lawyer wants to really be caught out doing that kind of thing. And frankly, the lawyers I've been dealing with over the years have been great lawyers on the other side of cases, and they're not the kind of people who do that kind of thing anyway. And the one time in recent memory where I got hit with a pile of documents at the last minute, literally walking into a hearing, it wasn't the opposing counsel, but their client who was clearly culpable for springing the documents on their own lawyer. I don't think the lawyer's to blame at all. And in that case, their lawyer was frankly as unhappy with their client as I was. And we just took some time to go through the documents, and then I proceeded. And the same will go in case if you have a client with vision loss or a witness with vision loss. It's important to alert the other side and the court that there is that possible need, so that if somebody wants to spring a document on them at the last second, they're going to face the fact that there's someone there who just can't read it. And so by letting them know in advance, they can prepare it. And if need be, you have to take an adjournment and say, I'm sorry, you've presented this witness with something they can't read. I want to give the witness a chance, and we're going to have them take a break, and we'll have someone read it to them and from beginning to end, which is what they're entitled to do. Let me talk to you both now about dealing with demeanor in the courtroom. How do you deal with knowing what the judge or jury's expression or the witness's expressions are in the courtroom, since demeanor is something that people focus on? What do you do, Shona?
Well, the first thing is that we have an advantage over people who have full sight in that I think we often pick up on vocal cues that maybe a sighted person wouldn't. So if it's a witness, I listen a lot to what they're saying and how they're saying it to read them. If I want to get a read on the judge or the jury, if I've been cross-examining for a couple of hours and I want to know if they're still with me, usually the officer in charge is seated beside me, and I just bend down and ask them for a read. But so it's a combination.
All right, Alexandra.
Well, I think a popular misconception out there is that body language is totally inaccessible to blind people, and that's just a misconception, because I do listen to hear what people's body language is telling me to the extent that it can. So I listen. Are they shuffling? Are they writing? Are they tapping their fingers? So there are a lot of audio cues that people give, and they don't really realize it. So I listen for those. But I also, when I'm making submissions to the court or to a tribunal, I will check in with a member or with a judge. And so I will, before beginning, to make sure that everyone's ready to hear my submissions, and I will ask, may I begin? And then as I'm concluding one point and moving to the next, I will check in and I will say, this is the conclusion of my submissions on this topic. I'm going to turn to this next topic. And I usually wait for their response. And that'll also give me an indication of their level of engagement in what I'm saying.
I'm going to add that I will usually have an articling student with me, so I may lean forward and ask them for some visual prompts on demeanor issues, or just have them note and later tell me, when so-and-so argued X, the judge was shaking their head or something. The tone of voice actually tells a lot, and I find, particularly if you're dealing with a witness, and because I do appeals now, I really don't deal with witnesses, but when you're dealing with a witness, I get a lot from their tone of voice. I've often thought that people are better at pulling a face to look like they're sincere than pulling a voice to sound like they're sincere, and so that gives us a bit of an edge. And I'll sometimes begin questioning with some fairly uncontroversial things for me to just get their tone down, to get a baseline against which I can compare when one's getting into something that's a little more complex or more controversial. The other gift these days are any judge with a laptop, when they're taking notes. I mean, you can totally hear when they're taking notes. And if there are 3 judges and they all have laptops and they're all taking notes at the same time, that's at least some kind of feedback that's helpful. Let me turn to one more very visual area in the courtroom, which is if people are dealing with visual evidence like photographs or objects, or people are doing demonstrative, a witness is doing something demonstrative like gesturing, he hit me here. What do you do? Alexandra?
Well, I asked for that to be described and gone into detail so that I can either respond to it or just be part of the process. So I'm not excluded by their gesturing.
Okay, Shona?
As far as exhibits go, I'm extremely well prepared. I have gone through all of the visual evidence with the police officer prior to trial, and we have selected together the evidence that I think is important, and we've put it in some sort of order that I can rely on, that I know what it's depicting. And then, again, as Alexandra said, if if the person is gesturing, I will say to the judge, would Your Honor put that on the record for us? And that helps down the road anyway, because it does create a transcript of that movement instead of just reading a transcript and saying, and he went like this, and the reader of that transcript has no idea that he's just smacked himself in the head or whatever he's done. So I will have the judge articulate that.
Let me just, again, add to it here. I think our presence in the courtroom as counsel, or if there's a witness with vision loss or a client with vision loss who needs these kind of things described on the record, I think that makes for a better record. Because the Court of Appeal, if they read a transcript, are in the exact same position as a blind person in a trial courtroom. They don't see anything. And so they need that put into words just as much as we need it put into words. One last example where we may need an accommodation in the courtroom, but it's easy to do and it makes the record better, is if people are going to refer to printed material in the courtroom, rather than simply standing up and saying, Your Honor, we rely especially on the third paragraph on page 12, I'll pop up and say, I just wonder if counsel might read it out loud. Again, because I practice with a fairly, in the area of criminal appeals, with typically the same defense counsel who are fabulous lawyers on the other side, and the same judges the Court of Appeal are used to me, they instinctively just read things out anyway. But if I'm in a courtroom where the judge hasn't got experience with the opposing counsel doesn't, I just ask them to. And the same if text is going to be referred to a witness. Instead of just saying, what's your comment on paragraph 3, reading paragraph 3, invariably it's easier for everybody, and it also makes the record a lot clearer. Let me conclude this panel. I want to thank you both, and I want to conclude this panel with just 3 quick thoughts. The first is, there is an interesting area for where vision loss and being a court participant can become an interesting issue, and that's as a juror. In the 70s, it was illegal for a blind person to be on a jury. We fought to get that repealed, and it was. There have been instances, one was reported in the Welland newspaper a few months ago, where a court stood aside a blind person or a person with low vision from the jury pool who wanted to be able to serve. If it's going to be a case which is going to turn on making determinations on very specific visual things, that might be an area where vision would be an important thing to have. But a jury is supposed to reflect the aggregate experience of the community, and one of the experiences of the community is people who assess credibility of other people every day by tone of voice. And that's what people with vision loss do. And just as visual monitoring of demeanor is not foolproof as an assessment of demeanor, having the added perspective of someone with vision loss could be a real asset to a jury in an appropriate case. The other point I want to conclude with is, or 2 points I want to conclude with are these. In every case, whatever be the disability, the best piece of advice is just ask. Do you have a degree of vision loss? If so, how can we provide information to you in an accessible format? What do you need? If it's opposing counsel, what does your client need? Most law firms, if not all law firms, are now equipped to scan documents and perform optical character recognition. It doesn't require you to buy anything new. You're equipped to do that right now, and that may meet the needs of many, if not most, if not all. Finally, if you watching this program, this webinar, if you're experiencing vision loss as you proceed along in your career, I want you to know that there are resources available for you to be able to continue in your practice. Best advice is to say, get in touch with me. My email which I hope is in the material that's available with the webinar, is david.lepovsky@gmail.com. About 20 years ago, I set up an association of blind lawyers called the Canadian Association of Visually Impaired Lawyers, or CAVL. We've been pretty much dormant, and I apologize for that, but we do have a capacity to put you in touch with someone in your community, if there is. But there's no reason why a person experiencing vision loss has to feel that they've got to wind up their practice, wind down their practice, not have a court practice or whatever. But certainly feel free to be in touch. In the US, there's not one, but two separate organizations of visually impaired lawyers who have annual conferences. They're quite an interesting bunch to get together with, and I have. And there's lots to learn from people's different techniques and experiences. Anyway, I want to thank our first panel, and at this point, I'm going to ask the members of our second panel to please come up, and Rob will be focusing the camera now to my right as everybody joins us, and our colleagues to my left will be off camera. We're about to delve into, welcome everybody. I'm going to have my colleagues go down the table, starting with Graham, and I would like you to just each tell us in a brief sentence or two who you are, where you work, and our topic is meeting the needs of people in the court process with intellectual disabilities. So tell us what your experience is or what you do in the area that connects with people with intellectual disabilities. So Graham, do you want to start?
Thank you. I'm an assistant Crown attorney from Niagara. I've been an assistant Crown for 14 years. I was a defense counsel before that. I have dealt with people with intellectual disabilities as accused, as complainants, and as witnesses.
All right, and next to you is?
Anna Marie Dodge, and I work at Regional Support Associates, and I am a dual diagnosis justice case manager assisting accused people with intellectual disabilities in Windsor and London courts.
And next to you is?
My name's Deborah Richards, and I work for Community Living Welland Pelham in the Niagara region. And I primarily work with individuals who have sexually offended and are involved in the courts, as well as people who have been abused. So they may be witnesses in court, and also families who have intellectual disabilities who have had their children apprehended.
Okay, and finally we have?
June Valacam from Kapuskasing Community Living. Been working there for 33 years. I work with individuals with a developmental disability, and as the other panelists, with court cases of sexual abuse and different things like that.
Okay, so first let me just talk for a minute, and then we're going to jump in with our panel. We want to talk about meeting the needs of people with intellectual disabilities in all aspects of the court system. And while my colleagues have a disproportionate focus of their expertise and experience relates to the criminal process, we don't want this to be exclusively a criminal law panel. We're going to try wherever we can to offer information and tips that will be applicable whether you're a civil litigator, family law, or whatever it may be. Intellectual disability is the current term that is being used. The terminology has evolved, and some who are just learning about these disability issues may scratch their head and go, they're changing the terms for everything. I don't know what the heck to use anymore, and whatever I say is going to be wrong. Best advice to you is don't worry about it, just ask. Ask what terminology people are most comfortable with. The terminology to avoid in any disability context is pejorative language. We prefer if you don't talk about people suffering from cerebral palsy or victims of blindness, people confined to a wheelchair, terms that make everything sound kind of negative or speak down to something, to a condition. Neutral terminology is usually the fairest, but when in doubt, ask. The term in vogue now is intellectual disability. Previously, and still sometimes used, are the terms developmental disability or developmental delay. And the older term that we all grew up with, and which we'll get to in a few minutes, is very much not preferred now and should be avoided at all costs if you can, is mental retardation or mentally retarded. they're all different terms that refer to the same cohort of folks, but the terminology has evolved, and the safest one to use in the professional context is intellectual disability. So I'm going to ask questions. I'm going to throw them out to our panel, and different folks are going to pipe up for different things or chime in as they wish. Could we begin with, could one of you just offer us a definition? What is an intellectual disability?
An intellectual disability is someone that has an IQ below 70 or marked deficit in adaptive functioning. However, the last year there's been a change in that, and that's the American Psychiatric Association has determined that the criteria is a bit different right now. So the DSM-5, or the Diagnostic Statistic Manual, 5th edition, has stated that that there needs to be both clinical assessment and standardized testing. So in other words, IQ testing that involves, let's say, Stanford-Binet testing or Wechsler, which is the IQ testing, with a greater emphasis needed on the adaptive functioning and not the
What is
IQ.
adaptive functioning?
So adaptive functioning is broken down into 3 areas, one being conceptual. So someone understands, do they understand time, money, literacy? The second section is social. So do they understand social responsibility, problem-solving skills? And the last one is practical. So those activities of daily living. So do they have the ability to understand how do they get on the public transit? Those types of things. So what they're saying is place more emphasis on the adaptive functioning to determine how that person is able to have an overall ability. The reason that this is especially important in forensic cases, but one of the other important factors is this is never, that IQ level of under 70 has never captured a few people that have low adaptive functioning. So for instance, someone with Asperger's syndrome, they often will rate at a higher level IQ-wise so they don't fall in the category of developmental disability. However, their adaptive functioning is extremely low, especially in the social area, that social responsibility, problem-solving area. Someone with fetal alcohol spectrum disorder as well, they may end up having an IQ of up around 80. However, that adaptive functioning is extremely low because of their expressive language skills, and those get them into they sound like they know what they're talking about, but they don't. So what happens is they're not understood in the courtroom, and they may not be treated fairly. So in that respect, it makes it a little bit easier to capture a whole other group of folks.
Okay, could you tell us a bit about the spectrum of different degrees of intellectual disability, the terminology that's used?
Right, so you're going to hear terms like mild, moderate, severe, profound. You'll hear those terms, and those refer to the level of functioning of that person. We try to stay away from those terms as much as we can. But it does kind of give a basis of where that person is functioning. So in other words, someone with an IQ of, let's say, 55 to 70, that would fall within the mild range. Moderate would be below that, and then severe range, and then profound.
And which is the majority of people within the 70 or below? Are they grouped at the lower end or the higher end?
The higher end. So the largest group of folks you're going to run into are going to be within that mild range of functioning. So they're going to have fairly decent adaptive functioning. They probably can get on the bus and figure out where the transit is. They can probably cook a few things around the house. Their personal hygiene, they can take care of that. Where someone with a moderate level, they're going to need a little bit of assistance. Someone with a severe range, severe and profound, they're probably going to require 24-hour supports and not have the ability, those adaptive functioning skills. And their IQ is going to be fairly low.
All right, can we treat IQ as like two different people with a 58 or are going to be the same?
Excuse me?
Are two people with the same IQ going to function at the same level?
No, not necessarily, because I think, they bring to the table lots of life experiences, and, they may have learned, if they were living at home with their mom and dad, and they were learning all kinds of functional skills in terms of daily living, that's going to present in a much different way than someone that maybe is 50 years old and lived in an institution for their life.
Right.
So they're going to show, their skill level is going to be fairly low.
Or someone that's living on the streets, has that street lingo.
Right.
Mm-hmm.
Yeah.
Okay.
Sure.
Let me so that gives us sort of basic terminology. Help me, what's the difference between an intellectual disability and a learning disability?
that often confuses a lot of people. The big difference is the cognitive functioning. A person with a learning disability isn't typically going to have a lower IQ. They're going to have difficulty possibly processing what they're hearing or explaining things that they've heard. And math disability, a very specific type disability. And there can be some overlap, but typically what may confuse people the most is that the people that we work with intellectual disabilities, they'll often say they have a learning disability to avoid the stigmatism.
So the individual with intellectual disability will self-describe as having a learning disability because
there's less stigma attached to that. They'll just say, I have trouble learning or a learning disability. It seems more accepted in society than having an intellectual disability.
Okay, and help us out with a bit more terminology here. The difference between somebody with an intellectual disability and somebody with a mental health condition, and what is a dual diagnosis? Let's talk about those two together.
So I think an intellectual disability is someone that has issues around cognitive impairments, as opposed to someone with a mental health issue that is more than likely going to have depression or schizophrenia or bipolar disorder or something like that. They're two very, very different things. The issue with intellectual disability, though, is sometimes people will do things like, let's say, self-talk, and they may present like they may have delusional behaviors, so it could look like a mental health issue. Not so much. So there is some issues around making sure the diagnosis is accurate. So the issue around dual diagnosis is that typically and some of you may have heard, the issue of dual diagnosis is often a mental health disorder such as depression, which may be accompanied with a substance abuse. In our field of intellectual disability, that is, a dual diagnosis looks a little bit different than that. So someone has a primary diagnosis of intellectual disability, and secondary to that, they would have a mental health disorder. In saying that, people with intellectual disabilities are a 30 to 60% likelihood of being at risk of having a mental health disorder. One of the reasons for that is because they often have genetic disorders. So there's this comorbidity. So you've got an intellectual disability and then you've got this genetic disorder, which is predisposed to a secondary disorder of, let's say, anxiety. So an example of that is someone with Down syndrome. They have a high incidence of having obsessive compulsive disorder. Someone that may be diagnosed with a syndrome called Fragile X syndrome often has anxiety disorders and attention deficit disorders. So you see they kind of go along with each other, and so you see a high incidence of mental health disorders with people who have intellectual disabilities.
Now, one will see in case law and some expert reports, or in common parlance, somebody referring to a person with an intellectual disability as having the mental age of an 8-year-old or the mental age of a 6-year-old. And I understand that's actually a problematic thing that we should discourage people from doing. Why is that? What's the problem?
Well, go
go
ahead.
on.
No, you
No.
go. Go, Graham.
Oh, Deb.
Well, I think there's a danger in that because they could have other abilities that are going to be age appropriate. So, in other words, someone that's 30 years old may have a sex drive that's completely normal, but by minimizing that and making them this childlike behavior, then you're not being fair to the person.
Okay, Graham, you want to say something?
That's the concern I have. If we start to quantify people, we don't realize their strengths and their weaknesses. We try to put them all on the same scale. And as we know from the court process, even people without intellectual disabilities, you can't put them all on the same scale, side by side.
People have a spectrum of different abilities, and even if you're going to measure anything by age, they may be able to do math at the level of somebody in, I don't know, grade 3, a particular individual. But on the other hand, they might be able to do other activities of daily living at a much higher age, if you're going to make the age the measure of performance. So by typecasting as one broad brush, this person has the mental age of an 8-year-old, gives you this sort of image of this child that got transplanted into an adult body that oversimplifies and misleads or can. All right, who diagnoses? If you've got a witness or a client involved in a court proceeding, and you think they might have an intellectual disability, and we'll talk more about what you do about it, but who makes the call?
Typically, that is done by a psychologist or a psych associate or a psychometrist overseen by a psychologist or psych associate. And as well, in the handouts, the Developmental Services Ontario is noted as a contact.
These are in the resources that are available through the webinar materials, the online materials with this webinar. Sorry, go ahead.
If assistance is needed and you're not sure where to turn and you think a person might qualify for supports with an intellectual disability, the DSO can be contacted and an assessment can be completed.
And again, we're going to get more into practical what do you do tips in a minute, but just so folks know, Developmental Services Ontario is part of the Government of Ontario, correct?
Mm-hmm. Yes.
And it's a central intake point. So all the services people can refer to there, and whatever services the person needs, it would just be going out from there, and they would refer the services outside of there.
And in your community, in each major disability area, there are some nonprofit service providers. So for blindness, there's the Canadian National Institute for the Blind, and for people with hearing loss, there's the Canadian Hearing Society. In the area of intellectual disabilities, the umbrella organization provincially is Community Living Ontario. There's a National Canadian Association for Community Living, but in each of your communities around Ontario, there is a local community living organization, and they're always a place you can call to at least get some information and get connected up with services or assistance if you need it. Now, just a few minutes ago, the point was raised that people with intellectual disabilities may have occasion to not want to use that label on themselves, but rather use the term learning problem or I have difficulty learning because of stigma. I want to ask you all to share some of the stereotypes or the attitudes that people with intellectual disabilities can face out there, which would lead them to not want to bear that label. Graham, you want to
start? The first one, I think most of these people have gone through life being abused and made fun of, so they often do not want to be the center of attention, which if they come into the courtroom as a witness or accused, they may be. Also, they've gone through life often with people not taking them seriously, not listening to what they say, not hearing them out. So they often perceive themselves as less worthy of belief or not the best historians. I think the courts have perpetuated that by saying people with intellectual disabilities may not understand the importance of telling the truth in court, may not be able to communicate their evidence, may not be the best historians of what happened to them, often behind closed doors.
And I think to add to that, what Graham's saying is that I've got an example for that exactly. A woman that I worked with many years ago, she was sexually assaulted by an individual, and when the court case came, the pre-trial, it was thought by everyone that she wouldn't be a very good witness. However, she went in the courtroom, and there were two other women who had normal intelligence who had also been sexually assaulted by him. So they let them go first, thinking that she wasn't going to be a very good witness. These two women went first, and they didn't give a very good account of what had happened. However, the woman that I was supporting, she went in there, and her account was so accurate, right down to detail of everything, that the fella ended up pleading guilty at the pre-trial. And the point of that story is this woman had Down syndrome. She was in a moderate functioning range, which people thought that was the reason everyone thought she wouldn't be a good witness. And here it was that, in fact, she was an excellent witness.
What other stereotypes or attitudes that can they encounter or can be common in society about them?
I think the main one is to treat the individual like you would any typical person that you meet. The talking down to them, they would know right away that you're determining that they're not going to understand you, or that because they're like a child.
Because people talk to them as sort of the way you talk to a little child?
Yes.
You'd be amazed how many times blind people get that one too, by the way. I'm not kidding. What about attitudes in terms of sexuality or
well,
stereotypes?
it's the same thing. If you're labeled as a 7-year-old and they won't expect you to have a sexual drive, or they're asexual because they have an intellectual disability, and that's not it. They're an adult like any other adult, and they go through the same puberty and everything that every other person does when they're reaching teenage years. They go through the same struggles, the same rejections, the same traumas as every other teenager goes through, those same pains of growing up. And people tend to forget that they may not understand everything, but the feelings inside are the same as anybody else. And they go through life experiences the same way we do, maybe more hurtful because they've been targeted at every corner of their life. They've been targeted and accused, and they're vulnerable, and they'll do things that to make you like them. They'll do whatever you say. So there's always that part in them that people figure they're just
okay. Stereotypes about correlation with violence.
Yeah, I was just thinking, to bounce off what June was saying, was, there is that belief, that asexual belief, but on the flip side of that, people often will say that people with intellectual disabilities are oversexed, in particular when they've been charged with a sex crime. So there's this thinking of oversex, so it's that opposite thinking as well. So.
Okay, let me jump now into the lawyer or paralegal has a client or a witness. How might they know the individual has an intellectual disability? And if they think they might, what should they do to find out if they do? I mean, do you say, hi, do you have an intellectual disability?
No, but I would think when I first meet a witness or a complainant, I want to speak directly to them, treat them with respect, and have them right off the bat tell me a bit about themselves. Often that will drop some cues as to what they do. I'll say, how do you get by? And they'll say, my ODSP, and that may be a good indicator. They may often come in with somebody. We ask if they want this person to be there, be participant.
When you say somebody, you mean like a support worker?
Well, I might perceive they're a support person, but I want to ask the person I'm dealing with, who is this person to you? And get a sense of how they interrelate with the person coming in. Are they from community living? Are they a parent? Are they from some other agency?
If they're involved in a court proceeding, either as a witness or a client, should counsel expect that they're likely going to be coming in with a support person if they have an intellectual disability?
I would think there's a good chance they may, but often we've seen as a private counsel, sometimes the support person waits out in the waiting room, and
right.
You say, who brought you here, and would you care if they joined us?
And are the questions you might ask the individual if you wanted to respectfully explore this topic, what might you ask?
I would ask if the support person, if they're willing for that person to be there. Are they willing to sign a release form where I could ask questions of this person, or they're willing to give information?
Right.
Are there anybody else that they would like to put on a side release that might be helpful to them
Right.
that could answer some questions they might have or I might
So
have
the support
about it.
person could be a good source of information to find out more. What about questions that you might ask of the individual that might help you get a better picture?
Well, I would initially engage them in dialogue, how they spend their days, a bit about their background, just to, as you do with any witness or client, size them up, see how to best interact with them.
Right.
I may ask, I think we have to avoid, if there's a support person there, avoid sort of talking behind their back about the person, or worse yet, sort of ignoring the person and engaging in a one-on-one dialogue with the support person in front of the person.
Right, as if they're kind of a third party.
Exactly.
And I think, as well, I agree with that, because my best experiences with working with defense lawyers has been when they've invited both parties in, the support person and the individual, and been talking to the individual, and then everyone is being asked the same questions. And I think it's just a much more respectful way of treating the person.
Right. Okay, let me go into the crux of it now. We've got a person who's going to be involved as a witness or a party in a court proceeding, civil or criminal. What kind of barriers do they face in taking part and being able to fully participate in the court process? What kind of difficulties might they face?
Well, I would think they experience many of the same barriers that every witness who's new to the court process experiences, albeit probably at an exaggerated level. They want to know what their role in the process is, and that has to be explained to them in appropriate language. They want to know...
By appropriate language, what do you mean?
Well, and that, I go back to my first stage. I'd like, by sizing them up, and by getting further input from the support person, you can see, get some sense of shorter sentences, sometimes simpler ideas, not compound sentences.
Yeah.
Maybe asking them more than you would other people. Do you understand that? Do you have any questions about that? Just sort of the problem, and maybe the other panelists can speak to, often initially when you deal with a person with an intellectual disability, or sometimes they present initially that they understand everything, and often if time is precious, you skim over the surface assuming they're following along.
And why do you get that impression if it's inaccurate?
Well, they've learned over time to compensate for skill deficits. So in our field, we call it cloak of competence.
Cloak of
So
confidence.
just on a quick skim of meeting the person, you may not realize. So that's why it's important to ask open-ended questions and not just wait for a yes or no and accept that. And when you're explaining something to someone, have them tell you what you've told them, but in a different way, so that you know they've understood
Right.
the concept.
Give them time to process what you've asked. Like, silence isn't something you should fear. Wait. A lot of times the answer will come. And if not, if they really didn't understand, and you can actually say, did you want me to repeat it, or did you want me to ask you in a different way, or can you tell me what you did hear from what I said? And usually if they didn't understand, they may say, well, you may ask me that again so that I can understand better. So it gives them an opening to show that there are things that I don't understand, you know.
And I think that falls within that cloak of competence as well, too, right? Because I was thinking of this couple that I was working with who had their child apprehended. And what they did was they would be asked if they knew how to do things, and they would always admit that, yes, in fact, they knew how to parent. The fear was if they said they didn't know how to parent, then that child would never come back to them. So there was never an opportunity where they would have said, I need help. Because if they knew that if they said that, then their child may possibly never get back in their hands.
And going along with this, they have to be educated about the court process. The best way to do that is, we've heard this before, is introduce them to the courtroom setting if you can, in an empty courtroom.
Right.
And attach the, I think it's easy for everybody, but especially people in this portion of the population to see the judge sits here, the judge's job is X and Y. You will be sitting here. People in this seat are expected to tell the truth. I, as a lawyer, will be seated at counsel table. You will be asked questions. And I think if they can see that within the context of the courtroom, that allows them to connect those functions to the various locations in the courtroom.
So explaining both the functions of what everybody does, using plain language, and also associating it with the different locations in the courtroom, so it's concrete. The person sitting up here, that's the judge. The person sitting over here, that's the other lawyer, and so on.
But I've learned from experience that, especially with counsel table, especially counsel that move around, I've learned once I said the defense counsel will be standing at the podium, and I think the person became somewhat confused when counsel was moving around to ask questions.
Right.
So you have to say the courtroom positions for some positions aren't static.
Right. So that's part of your explanation. Now, you take them in the courtroom once when it's empty to show them all this. Can that present a difficulty when they first see a full courtroom?
Definitely. A person that's seen it empty and quiet and peaceful, when they walk in, and they're not often packed, but sometimes they're quite full, and it can really throw them off and be distracting and difficult for them to relax.
Sorry, go ahead, Graham.
Counsel should be aware that, at least in criminal matters, there is victim witness services. They part of their bread and butter is introducing people to the courtroom. I know in Niagara that primarily they're used by the Crowns, but I've also seen them work with defense witnesses. I've seen them work, I think on one occasion they even became involved in a civil or a family trial. So they are a resource. Even if they won't sit with the person, they can give counsel some tips, or maybe if they have time and they're busy like we all are, they'll provide some further assistance.
So using plain language, explaining the process, bringing them in the courtroom once when it's empty, and then again when it's full. Are there aids that you can use in the courtroom to make things easier for them to understand or convey their evidence?
Well, first, if they have additional anxiety about being in the courtroom, there's, at least in the criminal code, and I believe there's equivalent case law in the civil area, that you can have a support person nearby to just give them some physical comfort. As far as testimony, often, again, like most witnesses, if they can be orientated or assisted by photographs or diagrams, often that assists convey their evidence. The one thing I suggest is, if you are going to show a person a photograph or a diagram, don't spring it on them for the first time in the courtrooms. Make sure they're abundantly comfortable with the diagram or with the photograph, and they've explained it to you before you get on the record in the courtroom.
Now, are you talking about, I mean, we always use photographs and diagrams when we need to in the evidence. Is this using it in a different way than we otherwise would?
I think it's sort of using it in a more enhanced way. You might not, you may ask a witness without an intellectual disability to describe a room, and the room may be a couch, 2 chairs, and 2 doors. And often we might accept that. evidence from a witness without an intellectual disability, but one who does have an intellectual disability might be able to describe things better, where things happened, who came into the room from which door, if they actually have that picture before them.
So you give them the picture and let them give their evidence by reference to the diagram or the photograph.
Yes.
Are there other ways you can use concrete objects to help them relate their evidence in a way that a person without an intellectual disability might not need?
Well, I think the idea of using some type of communication board, if they've got pictures that they use as their language, if they don't use words for their
Right.
speech. So I think those are.
Now that will also broach us into a much bigger subject, which I hope we'll deal with in a future program, dealing with people with communication disabilities and who communicate through alternative means from the spoken word. But that's just a taste of where it can come up.
If I could just go back to I wanted to bring up what Graham and Anne Marie were talking about.
Sure.
Using simple language, and then Anne Marie said using restatement. I was thinking of a case where I was working with a fellow that he had breached his probation order, and he wasn't to go near. The statement was on his order that he had to be 1,000 meters away from the victim. And the judge did a really good job at explaining what that would look like. You can't go near him and whatever, but what we found out was that adaptive piece, he didn't understand what 1,000 meters was. So, of course, he came into too close contact, the police were called, and he was put in jail. So we were in court, again, trying to get him out on this breach, and I explained that to the judge, and the judge did an amazing job and realized the fellow attended in taking that language and trying to break it down for him. Knew that he went to the hockey arena quite a bit and said, well, do you know how long a rink is? And he said, yeah. He says, okay, 2 rinks, you can't go within 2 rinks of the person. That he understood, you see. The 1,000 meters was lost. So, that could have been prevented had we done that in the beginning. And then another case that I was working on, again, using that, really talking to the person and making sure they understand, was a fella that one of his was he couldn't have any contact with a person. So the judge again went through everything and said, if you see him, what are you going to do? I'm going to walk away. He went through all these steps. About 2 weeks later, the young man wanted to apologize to the victim and phoned him. And when I asked him, and next thing I know, he's in jail, and I'm visiting him in jail, and I said, why did you do that? And he said, well, that wasn't contact. You see, it's using the language they understand and making sure, using restatement, like, tell me what I just said, tell me what that order says, and breaking it down for them. So that, as a preventative measure too, so that it's fair too. It's a fair system.
Okay, I want to let me just deal with one last area of possible assistance, and that is court scheduling. We are used to a court day, we who work in the courtroom, of getting there for 10 and it breaks at 11:30 and you tell your stomach that's when you can go grab something to eat, and 11:45 we're on till 1, and then 2:15 till 4, 4:30, whatever it may be. Are there instances where we should be adjusting that to accommodate people with intellectual disabilities, particularly if they're going to be testifying?
I believe there are. I believe most judges, if they're alerted to those issues, will accommodate those. Often it's the support person and the person themselves that can tell you what their daily routine is, when they eat, when they're at their best, when they're at their worst. The thing we have to be most cognizant of is often we tell people that they're going to, and all witnesses, but especially in this segment of the population, I try never to promise you're going to be a witness first thing in the morning, because invariably they're on after lunch and
Right.
they've faded by then. So we have to be, I think, even more sensitive to that Often, if they have a support person, the support person, I've often worked out signals if the person is flagging or losing interest or needs a break, and it's not apparent to me because I'm doing other functions in the courtroom, that there's some signal that is relayed to me that the person needs the break, and often I'll ask the judge for the break. And I find that the bench, for the most part, is very accommodating, no matter who makes a request to accommodate a witness.
And the defense lawyers, I find, are very accommodating as well. They may say, oh, don't have the person come until about 11:30. It's not going to be heard first thing. So,
Right.
Yeah.
All right, the last thing I want to address briefly, it focuses on the judge. I've done a lot of training for judges on disability issues, and it's been my experience across the board that they are eager to accommodate people with disabilities in the courtroom, whether it's counsel or clients or parties or witnesses. But they don't necessarily know someone has a disability. We don't come in with signs on us. They also don't know what to do. How do you convey to the judge that a witness or party has an intellectual disability, especially if that label is one that the individual may not be comfortable with? And how do you educate the judge or the court on how that person conveys how they function and what they might need? Let me start with Graham.
I've adopted a term, and I don't know if this is right or wrong, but I said the next witness has some unique needs. I am going to I call them almost an introductory witness, a support person like Debbie, or a parent, if the parent's not otherwise a witness, to give the judge some background about the witness. The witness is maybe just to remind the judge that this is a human being, this is a person entitled to respect, but here's what this particular witness needs, be it plain language, be it frequent breaks, be it the person has a relatively short attention span. I find that often the judge appreciates that. That also alerts the judge what to look for in the witness. It also alerts opposing counsel about the person. We can also get that to a lesser degree from the person themselves when they first testify, have them tell the judge something about themselves, and that, much like an introductory discussion with counsel, that tells the judge, it gives the judge a feel of the person before you get into the material evidence of the case.
In my case,
Yeah, go ahead. Sure,
in my
go ahead.
case, working with the accused, the judge won't often actually hear the person speak or have a lot of interactions with them. So the lawyers will often ask that I do up a little notation of what the person's diagnoses are, what their support needs might be, and just some possible recommendations if the person does end up with probation, things that might work better for the probation orders to help them not breach.
Just to conclude this panel, I might just draw on a theme that came out in our, really in our first and our second webinars, dealing with different disabilities, mental health issues and so on, which is in some areas, the disability is sort of concrete, easy, and quantifiable. Somebody can't see, somebody can't hear. The accommodation is a specific one. They need sign language, or they need captioning, or they need large print, or whatever. But there's some other disabilities where the condition is, like an intellectual disability, is harder to specify. And in the end, perhaps the most respectful way to convey it to the court is not by labels, but by describing needs. So by using Graham's language, this individual has unique needs. It is helpful for this individual to have questions asked in simple language and plain language, to use photographs that may assist in pointing to things or explaining things. The kind of tips that we've just heard, you should use simply listing them. What you label it as doesn't matter. By not waving a label like intellectual disability around, it may help that individual feel a little more comfortable in the court process themselves. I want to thank the panel, and I want to ask Rob, our erstwhile audio-video person here, to pull the camera back so we've got everybody. We have our Shona and Alexandra are now both here. And we're now in our concluding session, so we're going to take just a couple of minutes to see if any questions are coming in. Graham's the lucky guy who's got the iPad. I can't read it from here, so...
Well, there's not much to read right now, so...
Okay, we not got questions coming in?
I'm told no.
Okay, that makes it easier. Well, then let me offer some concluding remarks and thank our panelists for their contribution. Let me say this. Number one, we welcome your feedback on this program. What was helpful? What would you prefer to have more of? What would you prefer to have less of? We're looking at doing, as I indicated before, a couple of additional programs on this topic. I'd be interested to know what disability topics we haven't covered and that you would like to learn about. If you encounter any accessibility needs on the part of a client or witness or yourself, remember that each major court facility has an access and accommodation coordinator, and let's feel free to call them, alert them to the need as early as you can in the process, so that they can try to put accommodations in place that will meet everybody's needs. If they tell you that the request you're raising requires a formal judicial approval, you may have to actually bring a court application. Other sorts of things can be dealt with informally at an administrative level, but it's important to raise it as soon as possible. The next thing I want to ask or bring to your attention is, as a result of the Weiler Committee report, there is a permanent committee called the Ontario Courts Accessibility Committee. It meets 4 times a year. I have the privilege of serving on it. We've been operating since, I believe, 2007. The committee is made up of representatives of the legal profession, the judiciary at all levels, and the Ontario government. And our job is to oversee the implementation of the Weiler Committee report. And we're often the place where, if barriers are coming up, we try to find out ways to fix them and to bring to the right party's attention, whether it's the government or the courts, how they might fix it. If you are experiencing barriers, either as a lawyer or paralegal, or your witnesses or clients are, and the court's accessibility coordinators are not able to resolve them, please bring them to our attention. That's what our committee, we're not there to sort of go out and fix things in individual cases, but if we know a problem is coming up, we could try to find a bigger solution so it doesn't come up again. Easiest way, just email me as a member of the committee, david.lepofsky@gmail.com, and I'm happy to help you out. Because I'm not in private practice, I can't give advice on individual cases, but I can bring issues forward to the committee that we could try to get addressed. May I also, just as we're wrapping up, remind you that under the accessibility standards that were enacted under the Disabilities Act, depending on where you work, the organization where you work may have an obligation to establish an accessibility plan and policy. If you're a private sector law firm and you have at least 20 employees, you have an obligation to not only have an accessibility policy, but to train your staff on it and to establish a customer feedback mechanism on it and to file a report with the government confirming that you've complied. There are other obligations that are in effect under the Integrated Accessibility Standard. Check out the links that we've provided to you and make sure you're on board. Everything that is required to be done under the accessibility standards that have been passed to date are the law. They're also good for your organization. They will make you more effective at serving your clients, if it's a private sector firm, if it's a public sector operation, at serving the public. If there are no more questions, I think we're going to wrap up just a little bit early. I'm going to thank our panelists, and we look forward to the next time we can present to you. So from Toronto, we're signing off on a day that happens to be, around the world, the eve of Global Accessibility Awareness Day. It's already Global Accessibility Awareness Day in New Zealand and on the other half of the planet, and it will be here in Toronto as of May 15th. So we're happy to have been able to address this topic by coincidence at that time. Thank you very much.